Good afternoon. My name is Christopher Diorio, and this is another edition of ChrisChat. Again, I am an attorney in Massachusetts, practicing as a trial attorney, also an educator in college, teaching constitutional law and civil rights and liberties. What I want to discuss today is specifically the Gavin Grimm case, but more in general, the idea of what are transgendered rights in terms of Title IX and the Equal Protection Clause. First, the Gavin Grimm matter came back into the news again this week after the Trump administration had a policy shift, and the United States Supreme Court decided that they were not going to hear the matter as they scheduled. They had placed the matter on their calendar for hearing in March. However, this past Monday, they decided that they were no longer going to hear the matter. So what I want to do with you today, if I may, is go through some of the specifics of the Gavin Grimm matter, in terms of the facts, how the case has progressed, the chronology of the case, and then to discuss the law that applies, or at least will be applied, and how it should apply in certain respects, both pro and con regarding this. First of all, Gavin Grimm is a transgendered boy. Gavin is 17 years old. Gavin, at birth, was born as a female, with female genitalia. However, from an early age, Gavin identified solely as a male, and as such was diagnosed with what is known as gender dysphoria. This is a medical condition evidenced by distress, psychologically and mentally and physically, regarding the incongruity between what your assigned gender is at birth, or your assigned sex at birth, and your gender identity. How you feel that you are, who you feel that you are truthfully inside. As a result of this diagnosis, Gavin engaged in or was treated with, and has continued to be treated with, hormone therapy. Gavin changed his legal name from his birth name to Gavin, and lives his life as a male. The only thing not male about Gavin is his genitalia. Gavin has not yet undergone sex reassignment surgery. That is something that apparently is in the offing in the future, but he's young. He's 17. Gavin's family alerted his school. Gavin lives in Virginia, in Gloucester County. Gavin alerted the school at the beginning of Gavin's sophomore year about the gender dysphoria aspect of his diagnosis. And the school at that point, because he was transgendered, the school was initially very supportive. Gavin was allowed to be treated as a boy. All of his teachers in the school treated him as a boy, and specifically allowed him to use the boys' bathrooms. This lasted for approximately 7 weeks, until a number of individuals in the community where Gavin resides discovered what was going on with Gavin, and began to complain to both the school and to the local school board. As a result of these complaints related to Gavin using the boys' restrooms at his school, in November of 2014, the school board in Gloucester County, after these complaints from residents, had a public hearing related to this issue, and one of its members created or proffered a policy change. The policy change said that, in essence, that everyone had to use the facilities that were limited to their biological genders. In essence, what you were born as. So Gavin, who was living his life as a boy, would have had to use female restrooms. What they also said in this policy was, recognizing the transgender aspect, that students with gender identification issues or gender identity issues would be provided an alternative, appropriate private facility for their use. So what you have here is a, for want of a better term, and to go back into our not so proud history, a separate but equal facility. That this was something that was specifically for Gavin and other transgendered or gender identity individuals to use. Gavin had a problem now. Gavin could not being in the physical appearance that he was, living the life that he was living, if he went into a girl's bathroom, the biologically assigned bathroom for his particular, for his body, then the girls would see him come in and they would have a negative reaction. They would, ostracize him, feel negatively towards him, etc., and that would inhibit his ability to socialize and to socially change or to morph into the male body that he was going to be, the male life that he was going to be living. But also they provided this unisex gender identity bathroom, this separate but equal facility. And that was as far as he was concerned, stigmatizing as well. Turned him into a freak show. That this is his, this one place. This is just his bathroom because of who he was. Emphasizing for everybody that he is different. And again, this would undermine his social transition, and this is not what you're looking to do. So in June of 2015. Gavin sued the school board of Gloucester County and filed suit against them and asking for an injunction keeping them from enforcing this new policy, and further claiming that their actions towards him violated his rights under Title IX and the Equal Protection Clause of the 14th Amendment. We'll discuss those laws in a second. In July of 2015, just about a month or so after the case was filed, the case appeared on the docket in the United States District Court in Virginia, and they orally dismissed, after a brief hearing, they orally dismissed his Title IX claim. They never acted on the equal protection claim. That still remains out there and has not been discussed, and we'll talk about the importance of that in a little bit. They heard further evidence regarding the injunction, and then in September of 2015, the United States District Court in Virginia said in their ruling against Gavin that Title IX deals with sex discrimination and uses the specific term sex, that because this language or this term is not ambiguous, at least as far as their interpretation was concerned, that Title IX does not deal with protections for or mention even other concepts such as gender identity or sexual orientation or things of that nature. And because it doesn't say anything, those particular individuals are not protected. They went on to state in a number of other, as far as the decision was concerned, that it was going to make other students feel uncomfortable and things of that nature to have Gavin in a boys' bathroom, but there would also be uncomfortability in a girls' bathroom, which is why they created this separate facility for him. So he appealed that decision from the district court. He appealed it to the Fourth Circuit Court of Appeals. The matter was heard and decided in April of 2016. And at that point, the Court of Appeals in the Fourth Circuit reversed the decision of the district court and said that the case law, in looking at this case, whenever you're looking at what an agency's interpretation of its own rules are, that should be given weight. Now, we have to step back a little bit. What does that mean? Well, Title IX was created in 1972, and it does very specifically refer to sex discrimination or treating people differently based on sex. But again, as the district court said, there's no statement inside as to what that means. So now you have the Department of Education with a policy that applies to them, that they're busy taking care of. And they are responsible for enforcing the educational amendments of 1972, Title IX specifically. So as such, the Civil Rights Division, the Office of Civil Rights within the Department of Education in January of 2015 wrote a letter to all of the schools that are covered by Title IX, pretty much every school that is, taking federal funds. We'll talk about how Title IX applies in a second. But they wrote a letter, and pertinent to this is this language, that when a school elects to separate or treat students differently on the basis of sex, a school generally must treat transgender students consistent with their gender identity. So the Department of Education sends this letter out in 2015 that says if you have separate facilities and you have transgendered students, then those transgender students should be allowed to use whatever facility they identify with. This is what I will refer to going forward as the guidance letter. This came from the Department of Education, in essence, to guide all of these schools, all of these federal entities to understand what it meant when you talked about sex, how Title IX would address that. So the Circuit Court of Appeal, taking that letter, said that because the agency is fixing an ambiguity related to, the district court decision said, well, we don't know. It doesn't say anything about sex, so in essence, we're going to stick with just this definition. What the Court of Appeals said is, well, that's the very definition of ambiguity. We don't know what this means. The Department of Education just told us what it meant in this letter. Therefore, we give them weight. We give that opinion weight, their letter. And so they granted the injunction, allowed the bathroom use to take place, and remanded the case back to the district court to be heard fully on the merits. So it went back, and then the school board appealed that decision. They appealed it to the United States Supreme Court, and they presented three questions. First of which was whether the court should allow for this interpretation, this letter to take place and take precedence. Secondly, it's called deference to the DOE. So whether this deference extends to an agency letter that is not necessarily the law. It's just simply, like I said, guidance. And the third question was whether the Department of Education's interpretation of what Title IX meant is a valid interpretation. So basically, is this letter supposed to be the guiding principle? And secondly, and more importantly, are they correct in terms of what coverage Title IX provides? Now we have an election, we have a new administration come in. And in February of 2017, February 22nd of 2017, the Department of Education, under the Trump administration, withdrew the guidance letter. They, in essence, said that this was drafted without due language they used, drafted without due regard for the primary role of the states and local school districts to establish educational policy. Basically, a states' rights claim that the federal government had no authority to say to these schools what Title IX meant. An odd argument, to be sure. But they withdrew this guidance letter provision, announcing that schools still have to take steps to prevent discrimination and bullying and harassment. But as far as what transgendered rights were under Title IX, the Trump administration took no position. As a result of this, the United States Supreme Court takes this case off of their docket because now the driving force in this case was that guidance letter. Because that guidance letter no longer exists, now the case has to be heard down at the lower court level, specifically the Fourth Circuit Court of Appeals, as to whether or not the Department of Education's determination as to what counts as sex in terms of what's protected, whether sex includes transgender students. That's where we are right now in terms of the facts. So we have an open question before the Fourth Circuit Court of Appeals and, in all likelihood, in front of the United States Supreme Court, likely within a year to 2 years, depending on how fast the Court of Appeals addresses the matter down below. Now, what is the law? What exactly is the law? We might have heard the term Title IX before. It might have been bandied about in discussion. Title IX refers to Title IX of the Educational Amendments of 1972. It's an offshoot of the Civil Rights Act, but these specifically address the rights of individuals regarding educational access. One particular section, Title IX, addresses sex discrimination. And what it says, the law specifically, and again, I'm going to read directly from the law so that you understand it, and then I'll interpret. No person in the United States shall, on the basis of sex, there's the language we're talking about, be excluded from participation in, be denied benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. All right? So first of all, here's the language that we have to deal with. First, you have to define sex. Then you have to define who it is that this all applies to. Then you have to ask, was this person discriminated against? All right. They go on to define what an educational institution is. Any public or private, if they're here's the question, are you receiving federal funds? If you're receiving federal funds as an educational institution, you are subject to the rules of Title IX. So that means any public or private preschool, elementary school, secondary school, vocational, professional, higher education, secondary educational school, all of those apply or have Title IX applied to them. So they're all covered. Anybody who receives a penny's worth of federal assistance is subject to Title IX. There are some exclusions, however, institutions that are not covered by Title IX. And a lot of these will be very familiar, but I'll go through them. An educational institution that is controlled by a religious organization, and if this particular Title IX is inconsistent with the religious tenets of the organization. So parochial schools, religious institutions that are educational, Title IX may not apply. The military schools, any educational institution whose primary goal is the training of individuals for military service, including the Merchant Marine, Title IX doesn't apply. Institutions of undergraduate education that has a history of educating just students of one sex. So exclusively female schools or exclusively male schools, Title IX does not apply if you have a historical basis for this. It goes on to discuss one other thing that's not covered under Title IX is any scholarship or financial assistance awarded by an institution of higher education because the individual has received an award in a pageant in which the attainment of such award is based on a combination of factors related to appearance, poise, and talent. What this means is that beauty pageant winners are not subject to Title IX. Go figure. What Title IX addresses is three different types of discrimination. First, is a person being treated in a disparate fashion? This is otherwise known as disparate treatment. Disparate treatment refers to people who are being treated separately or differently based on a particular sexual classification. In the case of Title IX, the prohibited classification is sex. So under the disparate treatment theory of discrimination, the question that you have to ask is this institution, through its officials, treating people differently based on sex? So Title IX covers disparate treatment. Title IX also addresses disparate impact. What does that mean? You may have a facially neutral law or a facially neutral policy in your educational institution, but if it affects one gender more than it does another, then that is considered a disparate impact under Title IX, and that can be addressed or taken away. Under this theory, intent doesn't matter. The core question has to be, did this recipient, the institution, violate regulations through a neutral procedure or practice that has a disparate impact on protected individuals? The third thing that Title IX addresses is retaliation, which is not really present here. One thing that's very important about Title IX, as applied to the Gavin Grimm case and HB2 down in North Carolina and a number of other states that have copycat laws regarding the bathroom bills, which are coming up all over, there is a particular section that was appended to Title IX in 1975, which reads as follows. Under the Title IX common rule, recipients of federal financial assistance must not discriminate in providing facilities on the basis of sex. A recipient may provide separate toilet, locker room, and shower facilities on the basis of sex. In essence, they're allowing discrimination if you're going to separate men and women in terms of this. However, such facilities provided to one sex must be comparable to the facilities provided to the other, separate but equal. So this is the language that's being used. That's what Title IX is. Title IX is the question that needs to be addressed in terms of the Fourth Circuit Court of Appeals as to whether it applies. But there's another part of this case that we aren't really addressing in terms of the rights of transgendered individuals to have access. and that is the Equal Protection Clause of the 14th Amendment. Are these individuals, these transgendered individuals, entitled to a certain degree of protection based on the Equal Protection Clause? This has not been addressed in either the District Court or the Circuit Court of Appeals. They've only addressed the Title IX issue. The equal protection aspect of this has not yet been vetted through a court. First, what is equal protection? The Equal Protection Clause comes from the 14th Amendment, which was one of the three post-Civil War amendments. The 13th Amendment abolishing slavery, the 14th Amendment creating certain rights for individuals, and the 15th Amendment addressing voting rights for former slaves. But the 14th Amendment is what we're talking about in terms of equal protection. I will read specifically from it. And I apologize when I read specifically from the law, but I don't want my interpretation to get caught. I want you to actually have the language. And oh, by the way, if you have one of these handy-dandy constitutions, which I have been talking about for weeks now, you can actually read the amendment for yourself. And by the way, if you do not have one of your copies, again, I extend the offer. If you give me your address, I will send one of these to you free of charge. You should all have this. This is an essential bullet in your American gun. Amendment 14, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction of the United States, which, by the way, means illegal aliens. Anyone who's in the country and subject to our laws is covered by the 14th Amendment. Are citizens of the United States and of the state wherein they reside. No state shall make a law which shall abridge the privilege or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The laws apply to everybody the same. That's what the Equal Protection Clause says. It is one of the most litigated sections of the United States Constitution. Since the 14th Amendment was ratified back in 1865, the United States Supreme Court has developed different analyses for determining what type of protection people are entitled to. There are three different levels that people look at. If you are in a particular classification or a particular group, this determines how the law is looked at. With a challenge classification, the government has to show that a classification serves a compelling state interest, and that the legislation is necessary, and that addresses what are called suspect classifications. Those classifications historically are laws relating to race, national origin, religion, and alienage, whether you're from the country or not. Also, this particular analysis applies to fundamental rights, such as interstate migration, denial of your voting rights, access to the courts, and things that are deemed to be fundamental rights. Then you have what's called a middle tier or an intermediate tier of protection, and this is where we sort of run into a problem. The government in these areas simply has to show that the law serves an important state interest, not a compelling state interest, but an important one, and that it is at least substantially related to serving that interest. Now, the classifications that fall under this intermediate area are gender and illegitimacy. This is where we fall. Now you have to look at the question of, and at no point, at least not yet, have transgendered individuals been classified. This is why this case is so important, because at some point or another, the United States Supreme Court is going to have to address what transgendered people's rights are, where they fit. And if they refer to this as a gender thing, then that's where they're going to sit in terms of their scrutiny. The cases that the United States Supreme Court has decided that address gender issues usually indicate that the state's interest has to be exceedingly persuasive. So how does this apply to transgender rights, and why is this important? Well, if you look at it from Gavin Grimm's side, from the rights of transgendered individuals, under the Equal Protection Clause, if there is any kind of classification based on sex, it would have to meet intermediate scrutiny or be substantially related to this interest. But because these policies, these bathroom bills, are blanket bills and they're not very specifically related to the issue that they're cobbling together of the essential nature of privacy for individuals to be free from prying eyes, etc., which is what the district court said, they have to show that there's some safety concerns. And there's really no evidence. There are no facts on the ground, and there's an appalling lack of evidence here showing that there are any safety concerns involved with transgendered students using a bathroom. It doesn't exist. So when you're talking about equal protection, the equal protection law and the 14th Amendment requires then that bathrooms be made available based on gender identity. So that would be the pro side in terms of Gavin Grimm and other transgendered individuals. But there's obviously another side stated in the district court's decision and in many other decisions or opinions drafted in this case. They will say on the other side that the question truthfully is whether Gavin Grimm and transgendered individuals in general are being treated differently than other biological females. They are entrenched in the word sex as being defining or defined by your birth sex, how you are biologically assigned at birth. So if Gavin is not being treated differently, if transgendered students who are biologically one but identify as another are not being treated differently than other people of their similar biological classification, then there is no discrimination. The policy itself of having this separate facility, this separate but equal facility, is a facially neutral policy. And that Gavin and other transgendered individuals are welcome to use either the girls' bathroom or whatever bathroom is related to their biological assignment, or this special facility, this separate but equal facility that they've created specifically for people like Gavin Grimm. So there's the difference between the two and how this applies. The key, potentially, in determining how the case will fall down and what the court will look at, the key may very well be in a case decided just a couple of years ago. The key to how the court may look at this may be in the Obergefell versus Hodges decision, which granted same-sex couples the right to marry. Justice Anthony Kennedy, who I have said many times is the most powerful and influential person in American jurisprudence because he sits astride the fence. And as Tony Kennedy goes, so goes the court in many of these issues, specifically in terms of social issues. But in the Obergefell decision, Justice Kennedy wrote the majority opinion there, back when the court was a 9-membered court. Justice Kennedy wrote the majority opinion granting same-sex couples the right to marry. And in that decision, he explained that the Constitution promises liberty to everyone within its reach. You heard that language from the 14th Amendment, right? Everyone within its reach. And that liberty has to include certain specific rights that allow persons within a lawful realm to define and express their identity. Very interesting language that he uses there. Define and express their identity, allowing persons to define and express who they are. It's embedded right there in Obergefell, that language. Hence, the liberties that are protected by the 14th Amendment would then extend to intimate choices that define personal identity and personal beliefs. And again, the term identity is very important. It's right there in the Obergefell majority decision. Legal scholars in looking at this decision have said that the greatest achievement of Justice Kennedy's decision is not necessarily that same-sex couples have the right to marry and that that's been granted to them, but the greatest achievement here is how he's put due process and equal protection all together and created what they are terming the doctrine of equal dignity, that regardless of who you are or what you are, that the decision has established for same-sex couples freedom to marry, and that this above and beyond that was understood by pretty much everybody who looks at this as directly addressing the subordination of LGBTQ individuals. That this creates a bolstering of their particular rights regarding transgendered access. This is where we stand right now. If you have questions, I'll be happy to answer them. But right now, what you're looking at with this area is maybe Title IX is not the most fruitful area to take this case down. The real potential fruitful area would be the Equal Protection Clause, to allow for the 14th Amendment to be addressed specifically because this issue, or an issue similar dealing with personal identity, was front and center in the Obergefell decision. Perhaps equal protection is the right way to go. Even though this is an educational institution, Title IX and the Equal Protection Clause can work hand in glove. But what I keep coming back to, what I can't really avoid, and what I've yet to hear from anybody on the other side of things is this. We used to have separate but equal facilities. You may have seen pictures of them. There was, in many states down south, there was a water fountain for whites only, and there was a water fountain for coloreds only. Coloreds were to ride in certain portions of the train. White people were allowed to go in another. The seats were the same. The facilities were the same. They were separate facilities, keeping these people separate and apart. But in a sense, they were equal facilities. Separate but equal. Well, Brown versus Board of Education, at least I would have thought, addressed that in the decision from John Marshall Harlan, when he said that separate but equal is inherently unequal. That these separate facilities that they're creating for transgendered individuals are in essence segregating people based on their gender identity. Do we want to go down that road? Is this what we want to be? To declare for individuals that you are in fact to be treated separately. That this is not a great thing. That this is not a boon to these individuals to have a separate bathroom all to themselves. Ask yourself this question. Erase the word transgender from this entire discussion and put race in. Put regular gender in. Put nationality in. Perhaps we should have Christian bathrooms for one and Muslim bathrooms for another. Separate but equal. We should certainly allow that. At least that's what this rationale seems to be. Or should we do as we have done a long time ago and decide for ourselves, as Brown said, that separate but equal is inherently unequal, and this is not who we are? I see no questions being forwarded. Thank you again for allowing me to sit here and speak to you all. Thank you all for everybody who chimed in. I will be back with you next week. And as always, I am Chris DiOrio, and this has been ChrisChat.